Welcome, Ashok. And a
Thank
very
you,
quick
ma'am.
introduction to Ashok is the founder of a law firm which is called Factum Law, and he specializes in intellectual property rights, space laws, health, and pharmacy-related aspects, commercial contracts, and the list goes on. And he's been a practicing advocate. And much to learn from Ashok in today's session because he is hardcore into IP litigations. And he also shares with me quite a few interesting stories and cases of what comes up in the IP domain. So over to you, Ashok, and please take over the session.
Thank you, ma'am. So at the outset, please excuse me if I'm not able to be very audible today. So my voice is a little down. Ma'am, can I get the permission to share the screen? Okay, can everybody see the screen in front of them? So today I have the very tall task of covering not one but two different topics. So instead of going about it sequentially, I thought let me do it the other way around. So we'll focus on what is infringement, which is a complex topic in itself. How do you prepare for addressing IP infringement? Mostly from the point of view of a potential enforcement action. What are the kind of internal preparations that you'll have to undertake? What are the kind of external preparations that you'll have to undertake? How do you choose the appropriate mechanism to enforce? There are civil remedies, there are criminal remedies. In certain very specified circumstances, there could even be resort to alternative dispute resolution. So how do we then figure out which of the options to choose while addressing the subject of IP infringement is the other thing that we will cover. Last but not the least, today's topic will mostly focus on domestic enforcement, not international or cross-border enforcement. The reason being that cross-border enforcement is a distinct topic in itself. It involves a very broad discussion on where we are trying to enforce, what is the kind of legal system that they follow. All of that becomes a topic that becomes vast in itself. So therefore, we will only focus on domestic enforcement today. So let's first take a look at what is infringement, right? And let's not immediately worry about what the legal definition of infringement is, right? So let's just go with a common man's understanding of what is infringement. Anybody wants to take a shot at defining what infringement is?
Breaking of law.
Breaking of law. Yes, it is a violation of a law. That's right. What else? So let's assume that you're the owner of a trademark, right? And how would you go about defining what is infringement of your trademark? We'll take the simplest example with the trademark.
If someone copies that trademark, then it is infringement.
Perfect. That's a good answer. What else? Okay, no problem. So let us go with the understanding of what an IP owner can do first, right? Which is somewhat similar to conventional ownership rights. So if you own a piece of property, right? So let's assume that you've built a house on it. Would you have the right to ensure that nobody damages the house as part of your ownership rights? Yes or no?
Yes.
Yes, right? So similar to conventional ownership rights, even when the context of IP is concerned, you do have the right to guard the IP against damage, right? Now, damage could be a little more direct in the form of, let's take, for example, a scenario where BMW and Mercedes kind of have had this rivalry going for a very long time, right? And one of the recent ads of BMW shows the chief executive officer of Mercedes retiring from Mercedes. And then he is dropped home on his last day of work. He gets inside the garage, climbs into a BMW, comes out, and then the tag goes freedom at last, right? Now, this is a classic example of somebody trying to poke fun at a rival brand, right? In an extreme form, this can even take the shape of disparagement or defamation of the brand itself. Now, that is one of the key rights that you will have as a trademark owner, right? So guarding against damage is one of the first things that you need to keep in mind. Two, you have the right to guard against economic loss. So if tomorrow, for example, somebody wants to create the multiple sale deeds for your property just to ensure that the value drops, that is when you have a situation of Just give me 1 second. I think my dog needs to be let out. 1 second. Appearing from home has certain advantages and certain disadvantages. So, guarding against damage is one of the key rights that you will have as a owner of IP. Same goes for economic loss. Okay. Now, let us understand what is the economic loss that arises to an IP owner. Let us assume that you have gone ahead and patent protected a new earphone, right? So, with noise cancellation and everything. Now, what does that mean if you have patented it? What is the right that you enjoy because you have registered it as a patent? Anyone?
For the time being,
Varun,
I'm
you
not.
want? Yes.
Yeah, sure, sir. Like, sir, for the timing, I think for 15 years or for 15 years, you are the sole owner of that particular technology, and no one else can use that
Is
technology
it?
without sub-licensing or without licensing it from you.
Perfect. That's an excellent answer. So, in a nutshell, what you get thanks to a patent protection is the exclusive right to use and enjoy the patent, the subject matter of the patent. So, you have the right to manufacture, you have the right to sell, you can license, assign, and do all of that. Now, the best way to understand what is infringement is to say, what all can the owner of the IP do? And if somebody other than the owner is doing the same things without permission, that is infringement, right? Including inflicting loss or damage to the IP. Is it clear so far?
Yeah.
Whatever the owner of the IP can do, if somebody else does it without permission from the owner, is infringement, right? This is the simplest and easiest way to understand what is infringement, right? There are, of course, for depending upon the category of IP that you're dealing with, you could have different tests to determine what is infringement and what is not, right? So one of the tests, for example, in the context of patent is what is called as the pith and marrow test, where you identify all the elements protected by the patent, see if the rival product owner has the same elements covered by the patent in their product. And then when you compare the pith and marrow of both the inventions, if there is similarity, then there is a finding of IP infringement. Right? So similarly, from the point of view of trademark, if you have to stop somebody from using a trademark that has been copied, right? One of the things that you have to ask yourself is, what is the test of infringement? Right? And I'll give you an example. This is more complicated than it sounds. Two examples, right? First two trademarks, which are the subject matter of an infringement action, is Aisha and Asha. AYSHA, ASHA. This is for certain textile products, right? Option one, right? Is it infringement or not? We'll come to that. Option two, Lakshman Dhara and Amrit Dhara. Right? Now, in one of these examples, the court came back and said the trademarks are similar. In the other example, the court came back and said the trademark is not similar or identical. Going back to Asha and Aisha, how many of you think that the court held that these two trademarks are similar?
Asha and Ayasa. The pronunciation is almost same.
Almost same, right? Okay. How many of you think Lakshman Dhara and Amrit Dhara could have been held as similar or identical to each other?
I think it is not similar.
It is not similar. Okay. So the way the courts look at it is that in the case of Aisha and Asha, it pertained to textile products. So the court felt that the category of consumers will be slightly better informed and might be able to identify the nuanced differences between the syllables AYSHA and ASHA, and therefore held that they're not similar. On the other hand, in Lakshman Dhara and Amrit Dhara, which was pharmaceutical products, the court felt that we have to look at the question of similarity from the point of view of an average consumer with an imperfect sense of recollection and of average intelligence, and then see if it is similar or not. So there the court said that an average consumer with average intelligence, with imperfect sense of recollection, might just confuse Dhara as being similar and buy one thinking he's buying the other. And there the court held that it is similar. Right? So there is a variety of things that you need to keep in mind before you look at the question of similarity of trademarks. One, what is the product or the service that we're dealing with? Two, what is the market in which the products are functioning? Three, who are the likely consumers? Because, for example, somebody who's buying an Apple iPhone will obviously come from a different background as opposed to somebody who is going and buying a packet of Supari. right? The market segment is vastly different and different demographics are involved. So on an overall assessment of these factors, if there is similarity and identity, then the court assumes that there is some degree of infringement. The context of copyright is even more difficult to kind of gather, because when one movie is similar to another, and this was recently decided in a judgment involving an Indian movie called Bagi with an Indonesian movie called The Raid Redemption. And one of the tests that the court incorporated was what is called as the kernel assessment test, to see if the core idea of the movie is removed from it, right? And what is the effect on the movie itself? Does it still stand to rest on its own feet, or does the movie as a whole collapse and doesn't seem to make any cohesive sense anymore? If the answer is the latter, that the moment you remove the core idea, which is similar to the movies, the movie doesn't stand on its own, immediately the court assumes that there is infringement. But in the case of the Raid Redemption and Bagi, the court came back and said that even if I remove the core idea from the Indonesian movie, which was in the Indian movie, the movie still had so many other elements which allowed it to stand on its own feet. Therefore, they said that it is not a case of infringement. So, depending upon the nature of the IP, you will have to then ask yourself, how does the question of similarity and identity get assessed? And in that endeavor, never go by the first instinct that you have to say, hey, on the face of it, this looks similar. On the face of it, this looks like an infringement. You will have to go do your homework, pull out the relevant test of infringement from a relevant commentary or a case law, do your research, and then assess whether or not there is actual infringement or not. The first instinct that you have saying this is infringement or not infringement, that's the instinct that you ignore, right? Because how the law looks at infringement versus how you and I might look at infringement, absence the knowledge of law, could be two very different things, right? So two things to keep in mind. One, what is it that the owner of the IP can do? If somebody else is doing it, it is infringement. Two, to further bring a layer of logic and rationale to the whole exercise, identify the IP, identify the relevant test laid down in law, and then look at the question of similarity, or look at the conduct of the defendant from the prism of that test. And if the answer is that it is still infringement, then you have a definitive go ahead that, look, there is infringement and you have to proceed with taking some kind of an action. And the reason why we say that always go with the legal definition of infringement is, let me give you another example. Greenpeace came back with a computer game, and this was one of the examples I had already dealt with in one of my previous sessions. That game essentially required the player to guard olive ridley turtles from a corporation that was looking to build some infrastructure near their habitat. Tata came back and said this is a veiled reference to us, and therefore it is disparaging our trademark, which is a form of infringement recognized under 29(8) of the Trademarks Act. So it was not a case of somebody copying the Tata brand for similar products. This was a case where they came and said that you're taking unfair advantage of my trademark. You're using the trademark that I have in a dishonest manner, contrary to honest industrial and commercial practices. Right? So the court eventually came back and said, between freedom of speech and disparagement, freedom of speech and expression wins. Right? So in the context of advertising, for example, sometimes you could have comparative advertising, where one product brand may have an advertisement in which they speak ill of the rival brand. Right? Now, those are also instances where it could be infringement, though it's not infringement in the conventional sense, where we speak about one person copying the other. The third example that I can cite immediately in the context of trademarks to show you how infringement as per law is different from what we understand. If you go to the sponsored search results of Google, when you type a brand owner's name, sometimes you will notice that the rival brand owner's trademark is featured first, right? Well above the brand for which I've actually undertaken the search. Now, if the rival trademark owner seems to be giving the impression that by clicking on the link, you're actually clicking on the link of the brand for which you undertook the search, there is some deception in the search engine optimization that they're undertaking. In those circumstances, the courts have come back and said that you are trying to deceive the consumer into believing that while he clicks on one, he is actually going to the other. Therefore, it is a case of passing off an infringement. So, to summarize, first question, what is it that the IP owner can do? Is the other person doing the same thing without permission? to go to the relevant test for the relevant IP, look at the conduct of the prospective defendant from the eyes of the test. If it is infringement, it is infringement. 3, never tell yourself on the basis of the first glance of facts that this is infringement or not infringement. Go back and examine the legal position, because IP is an evolving jurisprudence. It's never static, right? There is, for example, in the context of defenses to infringement, one of the recent innovations in the United States is a combination of a descriptive use defense under the trademarks law and fair use defense under copyright law to form something called as descriptive fair use. With this involved a famous magazine that Oprah Winfrey had sued because they'd used a particular letter or a syllable which she said belongs to her. So finally, the court came back and said that they laid down a test of when it is descriptive fair use, when it is just used to describe a trademark. And holding that in that case, it was only a case of descriptive fair use, the infringement action was refused. So IP law is never static. There's always some innovation happening. There's always new developments in jurisprudence. So update yourself at the latest proposition of law on the subject and then arrive at the conclusion as to whether it is infringement or not. Any questions so far? Yes, Deepak, you have a question?
No, perfect.
Okay. So now there are certain defenses that you need to be mindful of, which also kind of goes to the root of how you choose your trademark, right? The reason why I say this is that if, for example, you're going to use a trademark called Xerox for photocopying machines, and today you have a situation where every photocopying machine is being called a Xerox machine, it's a classic case of a mark that originally was distinctive and later became generic, right? So when you adopt a trademark that is not inherently protectable as a trademark, name of a place, name of a person, then the enforceability becomes very, very questionable. The other thing to also bear in mind is in the context of patents, you could have a situation where the patent office by oversight grants you a patent. Later on, when you sue somebody for infringement, you might just have a situation where the defendant realizes that, look, what this man claims is patent protected was not patent worthy to begin with, because it was not novel, it was not inventive, it was not capable of industrial application. So the patent has been wrongly granted, right? Or there was a prior publication that essentially did not satisfy the test of anticipation. So in those circumstances, the defendant could very well defend the suit by saying, I'm not guilty of patent infringement, simultaneously go to the patent registry and challenge the patent itself and ask for a revocation of the patent. So the first kind of IP defense is to say that this IP is inherently not capable of being enforced. And even in the context of a trade secret, if somebody comes and says, for example, that they have compiled a list of consumers, and the list of consumers is actually not proprietary, and therefore the employee who had access to the customer information can't take it out. You have several judgments, including American Express Limited versus Priya Puri, that comes back and says that mere compilation of customer information is not a valid defense it's not a valid trade secret to enforce in the first place, because it is freely accessible. You're in the guise of confidential information, you're trying to stifle competition, and therefore we refuse to protect it. Same thing with pricing information. There are judgments in the United States to say that the manner of pricing of your product is not confidential. What is confidential is the tolerance to a profit margin, which means if you sell the product below a particular price, you know that your profit margin will not work out. That information alone is confidential and not the pricing information as a whole. So a lot of times you could have situations where you have a trade secret enforcement action being done, but because the plaintiff does not adequately describe the trade secret, measures taken to protect it, whether it has economic value, how many people know it within the organization, how many people know it outside the organization. So go back to the ingredients of a trademark. If those are not satisfied, then the defendant could potentially take the view that it is not enforceable to begin with. In the context of design or copyright, it could be a defense to say that this is not original. What is sought to be enforced, it already exists. Somebody has already done it. So if, for example, one of Makbul by Vishal Bharadwaj is a retelling of Shakespeare's classic tale, I think Macbeth, if I'm not mistaken. So in a situation like that, if somebody else is trying to recreate Macbeth and the Makbul producer comes and says that you can't do it, the defense could potentially be that, look, your work itself was not original. So how is it that I can be accused of infringement of your copyright in it. So these are potential defenses where you say the IP that is sought to be protected is inherently not enforceable. Now, the other thing could be that you have a conduct of the plaintiff that disentitles them to enforce the trademark. Now, one example could be that, or for that matter, even the trade secret. Now, one example could be a scenario where a rival trademark owner has adopted a trademark. The plaintiff is aware of the rival brand's existence, takes active measures to not suppress it, and kind of keeps encouraging him, saying that I have no problem, you please continue what you're doing, waiting for him to grow to a particular size and success, and then comes back and asks for damages for the infringing action. In those circumstances, because there is delay, because there is latches, because there's acquiescence, so the court could come back and say what was previously enforceable, you have now lost the right to enforce against a particular defendant. Right? So the other defense could be that you have a dispute on the identity or similarity, like Aisha and Asha that we were discussing. So there are different tests to determine when one IP is similar or identical to the other. So based on the test, if something comes across as inherently not identical or similar, then you could have that as one of the defenses. You could have defenses to say that this is in a different market. In the context of trademarks especially, I am allowed to enforce the trademark only in the jurisdiction where I have goodwill. So if I am not even in that particular region, say in India, and I'm only famous abroad, in the case of Hilton Hotels, the court came back and said the local Hilton Hotels actually has a better right over the use of the trademark Hilton than the actual parent Hilton Hotels. Same consequence followed with Toyota Prius. Right, so you could have situations where you come back and say that you may be great in another market, but in the Indian market you're nobody. So there could be honest concurrent use in the context of trademarks, own use, own name defense, where you say that the trademark is my own name, therefore I have a legitimate right to use it. In not all circumstances is it upheld, but bear in mind that these are prospective challenges to enforcement. So when you are in the process of brand ideation or in the process of ideating the IP, you may want to be cognizant of these potential defenses, reverse engineer it, ensure that your IP is actually circumventing all these potential challenges and is independently enforceable. So that's why it's useful to know the defenses. And the logic of ascertaining the defenses in an infringement action is the same. Identify what the IP is, go to the relevant statute if it is covered by a statute, figure out what the typical defenses are. Sometimes you will actually have it within the statute book itself. If not, case laws will tell you what the defenses are, under what circumstances the defenses are upheld. So again, it's a case where you don't yield to your own instinct about what a defense is. Because, for example, in India, the one thing that I keep hearing is that I did not know any better. Now, while I infringed this trademark, I did not know it was illegal. And we had situation where it was a famous water purifier company that we were representing. The rival brand had practically copied the entire trademark except one letter. And we were a multi-billion-dollar organization with vast amount of goodwill, extensive amount of money spent into advertising. That gentleman was probably active in a 2-kilometer radius within a particular locality of Bangalore. And his defense was that I didn't know it was illegal. So that kind of a defense will not fly. You have to go back and see what defenses the law recognizes and what does not recognize. If the law does not recognize it, there's no point in even entering into that debate to begin with. Any questions so far?
As has been said, ignorance of law is no excuse. So
absolutely. Now comes the next component of how do you prepare for an infringement action, right? What is the kind of internal and external preparation that needs to be done, right? So first question is it registered or unregistered IP you're dealing with? Because the kind of preparation that you have to undertake will be different depending upon whether it is registered or whether it is unregistered. Registered IP has a lesser standard of preparation necessary. Unregistered IP obviously requires a greater standard of preparation. But the ideal way to do it is to plan for enforcement as if your IP is unregistered, even if it is registered. Because if you've made the right kind of moves to enforce unregistered IP, chances are that you've also covered whatever you need to cover for enforcing registrable IP. The reason why we draw this distinction is that in the case of registration, the one burden of proof that is immediately taken off the table is you don't have to prove that the IP belongs to you, because prima facie proof lies in the registration certificate. The defendant or the respondent can come and rebut it, but ultimately your preliminary burden to show it belongs to you itself is taken care of. Whereas with unregistered IP, the burden to show that the IP belongs to you is itself very, very high. So meeting that standard will be difficult, which requires a greater level of internal preparation. Right? Now, the first thing to then also ask yourself is, what is it that I need to keep in mind to enforce my IP? Right? Because in the case of patents, you compulsorily need a registered patent. Without a registered patent, you can't enforce it. So there, one of the ingredients that you'll have to satisfy to enforce your idea or invention is a patent registration. But in the case of trademark or trade secret or know-how or copyright, registration is not always mandatory. Now, in certain categories of IP, the use is very important to be able to enforce it. So, for example, let's assume that in the year 1993 or 1994, while I'm abroad, I hear of this company called Yahoo. I come back and I register the trademark Yahoo, but I don't do anything. Right? I buy a domain name, I buy the trademark, and I just don't do anything. I'm not using it. So, in those circumstances, it's what is called as trademark squatting. The courts have come back and said, if you're not using the trademark, you have no right to it. This is especially a pitfall when you're dealing with unregistered trademarks, because if you have an unregistered trademark and you don't have proof of usage, then there is no ability to enforce it. Now, what is proof of usage? Sales records to show that the product is being sold. Now, for this, let's assume that your trademark is named XYZ. Your invoices ideally should show sale of XYZ, X number of units, priced at rupees Y. Right? So that you're able to show that the sales records relate to the trademark products and not something else. So that is one. Advertising expenses incurred, advertisements taken, press coverage, awards and recognitions granted for the particular brand. All of this will be evidence of usage, right? Including consumer service. So sometimes in the case of especially something like trademarks, you could have a requirement of not only having registration for infringement, but you would also need to show usage, right? So planning for the registered trademark enforcement as if it is unregistered is definitely useful. So the more you substantiate the usage, the more it strengthens the registration certificate. But never assume that registration certificate is sufficient and I can enforce my trademark with it. It may or may not carry you home in all instances, right? Now, the next thing, is it valuable? This is especially true for trade secrets. If you don't have a description of the value you attach to an IP in your own books of accounts, how do you then go back and say the other person's actions has caused this much of loss, right? Because only if I know the house is worth 100, I'll be able to show that because of the damage to the windows, the property worth 100 has been reduced to 95. Now, one of the things that most IP owners falter on is that they don't engage in a periodic exercise to value the IP. The intangibles are not appropriately evaluated except in the case of goodwill. So especially if you have something like trade secrets or trademarks or copyrights, where you may or may not always have the right kind of sales records, you might want to also undertake a periodic valuation exercise using a registered valuation professional at a predefined frequency, have the IP valued and ensure that it is featured in your books of accounts on the asset side of the balance sheet, to show that it actually has a valuation, especially when it comes to trade secret enforcement. Having this valuation record is very critical, because to determine if something is a trade secret or not, it has to have economic value. And sometimes the fact that it is on your books with that value itself is proof of the fact that it has got economic value and therefore is trade secret to begin with. Right? Now, one of the other easiest way to also track this is to track the cost of development of the IP, right? And this is also very critical, because what is the essence of IP infringement? That I have invested a particular amount of creative energy, time, and effort to develop the IP. The other person has not invested the time, energy, and effort, but wants to benefit from the outcome of my hard work. Right? So therefore, there is a need for me to stop him. Now, the moment you arrive at that, there's also a chance that sometimes your claim for damages could be not the actual losses you have suffered, but the unjust profit that your rival has made. Now, there being able to show that this was the cost of development of the IP is very important. And to be able to do it in quantifiable terms by tracking, for example, the salaries paid to employees involved in development of the IP, money invested into the infrastructure necessary to develop the IP. If you're paid a professional brand consultant to generate your brand, advertise and market it, and do the right kind of PR, those kind of invoices, right? If there's a patented product, how much of money and time and effort was spent into developing the patent? All of these becomes very critical, and that's something that every business must invest in to generate and keep handy these kind of easily verifiable records. It can't just be an in-the-air assessment of all these metrics. It has to be done by a professional. There has to be a sound science behind the valuation exercise. And that is very critical to not only show that your IP is valuable, but for the purposes of claiming damages at a later date. And any questions so far? So the other way to figure out what you need to do to prepare for potential infringement related action is that you reverse engineer the reliefs you're going to claim, right? So typically reliefs in IP infringement cases are of two categories. Legal remedies, which are mostly in the form of damages or compensation, compensatory damages being the most prevalent form of damages. Then there is equitable reliefs, which could be restraining the defendant from infringing on your IP, right? Now, each of this has a certain requirement. So, for example, if you're claiming damages, you have to show that this is the actual losses you have incurred. So, for that, one way to do it is to say that before the infringement started, I was earning rupees 100 per month. The moment the infringement has started, thanks to the proliferation of the infringing product, my revenues have reduced from 100 a month to 50 a month. And you show the sales data to say that this was what I was earning pre-infringement, this is what I'm earning post-infringement. The difference between the two is what I want as damages, provided you're able to satisfy the next requirement, which is that you have to show that this loss of revenues is attributable to the infringing action and not to some other factor. For example, you could have a situation where the demand for the product itself has reduced. So people are not interested in buying the product, or there is non-infringing rivals in the market, which is eating into your market share. Unless you're able to attribute the loss of sales and the loss of revenue and the hit to the business to the infringing conduct, you may not be able to establish the losses. So one way to do this is to hire investigators to go around, start discreetly collecting information about how much of sales is being undertaken by the infringer in the same market you're in. Is your product and the infringer product sold next to one another? Is a shopkeeper selling the infringing product instead of selling your product? So you try and gather all those details, see if you can quantify it to some degree, not to an absolute accurate degree. And that then becomes your preparatory work for a potential infringement action, right? And again, cost of development, tracking drop in sales pre and post infringement, attributing it to the infringing action, all of this is very critical. And that's the preparatory work that you'll have to undertake. When it comes to equitable relief, you need prima facie case, irreparable harm and injury, balance of convenience. Essentially to say that on the face of it, you prove that you have an arguable case to protect your IP, that the defendant's actions is causing irreparable harm and injury. You can't quantify it. And that there is balance of convenience, right? Which is that if you give me the relief, I will be benefited, but no harm is caused to the defendant. But if you don't give me the relief, I will be put to severe harm, but nothing will happen to the defendant anyways. So these three requirements you'll have to satisfy. Now, to be able to establish prima facie case, what you need is the data points that we discussed earlier. Sales records, you need to show advertising and marketing, need to show a cost of development. So essentially, if your legal, accounting, finance, sales, all these different functions in your business are able to work in tandem, develop a comprehensive strategy where business practices like accounting can complement your potential legal action, which is enforcement action, then you are able to seamlessly keep the documentation handy necessary to enforce your IP. So any questions so far? So the next question that arises is, you've gathered the data, right? Now, what do you do next? You straight away go to court, or do you want to probably take a chance and issue a cease and desist notice and see if the notice gives a sufficient warning for the other person to stop? Now, this is again not an easy question to answer for the simple reason that a lot of times, especially in counterfeiting and piracy, where you're some guy who's downloading movies illegally from the internet and selling it in CDs, you might be able to issue a cease and desist notice, but chances are that that fellow shuts shop, closes his entire business, comes to a different location in a different name, probably 1 week later, and restarts the business, right? So in those circumstances, a cease and desist notice will only mean that the infringer's name and location and everything has changes, but you're not really doing much in terms of stopping the infringement. So there, a cease and desist notice is probably not advised. You straight away go to a court and get an injunction, or you straight away go to a criminal law forum and then invoke criminal law remedies to see if the person can be arrested, right? But typically, in my experience, a cease and desist notice only does what is called as patchwork. You stop the infringement for a limited amount of time, and thereafter it anyway continues. So if your fly-by-night operators are the main problem. Yes, ma'am.
Ashok, for the convenience of the group, could you please explain a little about the cease and what is cease and desist order?
Perfect. So a cease and desist
Okay, sir.
notice is essentially a private letter or a correspondence initiated directly by the owner of the IP or through the legal counsel, essentially warning the other person that, look, I am the owner, I have the exclusive right to the IP, I have discovered that you are infringing it, therefore you're hereby called upon to cease and desist from using the IP without my permission, failing which I'm constrained to take legal action. It's a soft kind of a warning that you're giving to the other party before you go the full distance of initiating legal action, right? So this is cost effective. It does not involve too much of effort in terms of going to the court. So it's probably 4 or 5 hours worth of work to draft a good cease and desist notice and send it out, right? So if you do that, in some cases it is effective. So for example, you could have instances when there are legitimate businessmen who are not trying to just slave off your IP, but they simply know no better, right? Now, in those circumstances, a cease and desist notice could also mean that the person calls you and says, look, I'm very sorry. I didn't realize I was doing this. I'm going to stop it immediately. Please let me know how we can settle the dispute, right? So in case of legitimate businessmen, but who are probably ill-advised or probably not getting the right advice, a cease and desist notice without getting you to incur the cost and the time of enforcing it may just get you the relief, and it could possibly just save you a lot of trouble, right? So cease and desist notice, great idea for fly-by-night operators, but great idea for legitimate businessmen who are infringing, who can be traced, who have some kind of roots in the community. But if it's a fly-by-night operator who is very adept at changing shape, color, and form, then you might probably not want to do the cease and desist notice and instead straight away go to an enforcement action, right? Now, the other question that you also have to ask yourself is, what is the will and intent of the owner of the IP? Is he interested in going the full distance and initiating legal action and bringing the defendant's infringing activities to an end? Or is the intent only to send out a warning for the purpose of record to show that I have done something, right? I'm not allowed this person to just be around. So if the answer is latter, where he says, look, I just want to ensure that I make it formal that I'm not okay with his infringement, whether or not I want to take action, I'm not certain of, then the cease and desist notice makes a lot of sense. But if the IP owner wants to go the full distance, enforce the IP to the last mile possible, wants complete ownership over the enforcement effort, then you'll have to carefully weigh the pros and cons of issuing a cease and desist notice in the context of fly-by-night operators with legitimate businessmen, and then take a call on whether you want to issue a cease and desist notice or not. Right? So again, none of these things are to be taken for granted and assume that it is a mechanical process. That I have IP infringement, I issue a cease and desist notice, doesn't work, then I go to court. Each and every step requires some level of planning, some level of deliberation, some level of consultations with the IP owner. It's not something that you should be doing as a matter of course. Any questions so far?
Sir, how many times can we issue this notice, sir?
Really up to you, but bear in mind that the more cease and desist notices you issue, the less credible it seems, right? Because if they want to strike home fear that if you are serious about taking action, and then instead of saying one notice, you send 10 notices, one after the other, then the infringer is just going to assume that this is a classic case of somebody who's crying wolf, right? He will only bark and he will not bite. So you will have to, in my experience, anything more than one is not advisable, maximum 2 reminders, right? Failing which, best to either go to the court or let it go. Because if you're not serious, then you might as well let it go rather than sending more and more letters and only making it seem like you're not serious about your IP enforcement. So it really depends. According to me, anything more than one is not advisable, maximum 2 rounds of notices, right? Does that answer your question, Nagaraju?
Yeah, sir. Thank you.
Now, evidence gathering in IP infringement is extremely difficult and complicated and easier said than done. Right? And I'll give you an example. We were recently faced with I received the plaint for a trademark enforcement action, which required us to essentially file a suit in a tier 2 city against somebody who was copying my client's trademark as it is for the same business also. Now, when I got the plaint, what it said was it named the business itself. It was called XYZ something something house. So this XYZ something house was named as the defendant with the address and everything. But we did not know whether it was a proprietorship concern or a partnership firm or a private limited company. Now, what happens when you go ahead with the suit without you naming a particular form of business and naming the concerned owners is that your ability to later enforce a favorable order becomes very difficult. And sometimes the suit may not even be maintainable in case you don't name the correct defendant. So I'll give you an example. In a case where the defendant is a proprietorship concern, if you call the defendant XYZ so-and-so, represented by its proprietor, Mr. So-and-so, the Delhi High Court has held that such a suit is not maintainable. The reason being that there is nothing called as a proprietorship concern in the eye of law. There's only a proprietor. So your defendant should be described as Mr. So-and-so, proprietor of XYZ. Right? The marginal difference between the two, XYZ represented by proprietor Mr. So-and-so versus Mr. So-and-so, proprietor of XYZ, it seems so minuscule that it's almost comical that the law places that much of importance to it. But fact of the matter is that without that information, you could be taking serious risks in filing the suit. So sometimes being able to just gather the identity of the infringer is difficult. So how do you go about doing that? One way to do it is that thankfully with the advent of indirect tax laws being what it is, a lot of times these individuals will have the GST numbers or VAT numbers displayed on the principal place of the business. Now that GST data, if you trace back, you might just be able to figure out if at all there is somebody who's got the GST registration done in his or her name. That will then tell you whether it is a proprietor concern, partnership firm. So that's one way of doing it. The other thing to remember is in certain kinds of IP enforcement, the law requires you to also conduct a search in the database related to the IP to see if somebody has attempted to register the IP. Now, the reason why that is as important is because the Delhi High Court in multiple judgments, in fact, has held that, look, the duty is on the plaintiff to make the primary owner of the infringing business as the first defendant. Not even if you make him the second or third defendant, it is not sufficient. You have to make him the first defendant. So I'll give you an example. Let's assume that there's a manufacturer of infringing product. We'll call him A. He then sells the infringing product to distributor B, who then starts distributing the product. Right? Now, in a situation of this nature, the law requires you to make the manufacturer as the primary defendant, first defendant, and the distributor as the second defendant. If you interchange this, then it has, in some instances, even been held to be a case of a plaintiff approaching the court with unclean hands. And therefore, the entire equitable relief that you're asking for will not be provided. Because the rule is that if you want injunction or any kind of equitable relief, your conduct must be equitable. So if you're suppressing information, or if you're trying to hide the identity of the primary infringer by making them the second defendant and not the first defendant, then chances are that your entire infringement action itself would probably come crashing down. Right? So the more diligence that you gather in terms of gathering the details of the infringer, the better it is, right? And you always fall back on collateral sources, shops and commercial establishments registrations, trade licenses, right? Possible registrations of IP where the ownership details will be disclosed. So that is how you arrive at an identity of the infringer. Then, as we were discussing, if you are going to be dealing with unregistered IP, evidence of usage is very important. Revenues, awards, press coverage. You need to gather evidence from external stakeholders. So, for example, if there is a Christian Louboutin, the fashion brand, has a famous red-soled slippers or shoes. Please excuse my poor fashion knowledge. Now, this is a case where they try to stop other people from selling shoes with red soles, right? And one of the things that was challenged, of course, was that how can anybody claim ownership over just the red sole in a shoe, right? And in those circumstances, one of the things that the plaintiff would have to do is to undertake a consumer survey to show that consumers associate the red shoe sole, the red shoe, only with Christian Louboutin and not with any other brand. So consumer surveys done with the right kind of agency is also very important, statistically sound in its design, right kind of sample size. You should have the right integrity to the entire report of the consumer survey. But in those circumstances, consumer service becomes very important. Expert evidence is one area which is extremely interesting and equally challenging, right? When you need an expert to come and testify in an infringement action, and I'll give you an example in the US. There was somebody who, T-Mobile was the owner of a trademark where the predominant color theme was the color plum, right? Which I think is a variation of pink and purple somewhere. The rival trademark was in the color scheme of magenta, which is also an offshoot of a purple color. On the face of it, if you look at plum and magenta, they look completely different. Right? According to me, there was no infringement at all. But for what it's worth, the plaintiff decided that they're going to go ahead and sue the defendant for infringement anyways. Now, the defendant came back and said that, look, magenta and plum are not similar. So no consumer is going to get deceived. So why is this a problem? So how the plaintiff clinched the case is that they engaged this cognitive scientist as an expert witness called Donald Hoffman. He has written a famous book called The Case Against Reality on cognitive sciences. And in that book, he cites this example. So they engaged him to come and testify to the court whether or not a person can confuse the colors plum with the color magenta. And his testimony was that if the two colors are placed in front of the human eye, in real time, nobody's going to get confused. But the difference between the two is somebody has to recollect the color, right? It is not in front of them, but they have to recollect the color. The difference between the two is so minuscule that for the ordinary human memory, the threshold of the difference is not sufficient to help a consumer distinguish the two colors. Right? Now, that expert evidence provided by a cognitive scientist enabled plaintiff to get an injunction. So with IP, you never know what kind of subjects you'll have to get an expert in, right? Sometimes it could be just an expert on damages who can study the entire infringement and come back and say that, according to me, as a result of the infringement, this is the amount of losses that the owner has incurred. So damages assessment professionals could be very useful to quantify the losses you're claiming, right? So, and then bear in mind in IP cases, just because you're claiming compensation doesn't mean you're not entitled to equitable relief. Because the rule of thumb is that damages alone will not be sufficient to compensate. You will need a lot more than that. Right? So having the right kind of approach to damages assessment is very critical. The other example of expert evidence is the Google versus Uber trade secret dispute on self-driving car technology, where the allegation was that the employees of one carried forward trade secrets of the former employer to the new employer. Now, the defense that was taken was that, look, I have obviously got some skill in the field of automated car driving. That skill set nobody can own. It only belongs to me. Therefore, I've carried it with me. How do you say that it is an infringement of your trade secret? So when you say that I'm only relying upon the development of skill set, but actual information I'm not relying upon, that kind of an IP is sometimes called as a derivative, where based on the work with a trade secret, you have independent ideas. Now, whether or not this is a derivative not covered by the confidentiality agreement or whether this was identical, this was going to be determined by industry experts who could testify the similarity in the technologies developed for the former employer with the new employer, right? So the challenge often is knowing where an expert is necessary. For this, the IP lawyer cannot just fall back on legal knowledge. He has to be a general expert in a variety of fields, including, for example, understanding the literacy levels of the local population, right? So understanding, for example, what branch of science is relevant to an IP dispute, and then saying that expert has to be brought into the picture, right? Understanding and knowing one's own limitation, saying that while I can write a treatise on the law of damages, quantifying damages will require a damage assessment expert. So knowing what we don't know is often very critical for an IP lawyer. The more you read about everything under the sun, the better it is. And this example of plum and magenta, I didn't get from reading the judgment. I got it from reading the book called Case Against Reality, where the entire book is about essentially how the reality around us is not actual reality, and physics as we know it is not what it was. So sometimes from the strangest of sources, you can get information relevant to an IP dispute, right? So having that openness to knowledge from all sources, being generally a person who is trying to read as much as possible, watching as many informative content as possible, becomes very, very critical. Any questions so far? Now you've gathered the data and the information. You have been able to undertake all the due diligences necessary. Your IP is now in a position to be enforced. So how do you enforce it, right? So choosing the right forum for enforcement is also not something that can be done mechanically, right? So for example, if you're going to go with the Commercial Courts Act and you don't have an urgent relief for injunction or some other urgent relief, or if you have a relief which is urgent like injunction, but you haven't acted in a timely manner, then under Section 12A of the Commercial Courts Act, you are required to go to the mediation center first mandatorily, attempt a shot at mediation with the infringer, and then come back to the court, right? So if your dispute is going to be classified as a commercial dispute, because commercial disputes includes IP disputes, and if it is above the specified value, which each state has a different definition of. So if your suit is worth say 3 lakhs or more, in Karnataka it comes before the commercial courts. So in those circumstances, you will have to essentially look at mediation as an option, rule it out before you file the suit in the court, right? But suppose you have an arbitration clause with the potential infringer, like in the context of trade secrets where you have confidentiality agreements, and the confidentiality agreement also contains an arbitration clause. Then you can straight away go to invoke the arbitration clause, and for your interim relief, you only go under Section 9 of the Arbitration and Conciliation Act, right? So the next question is to ask yourself, is there an arbitration agreement concerning the subject matter of the dispute? The answer is yes, then chances are that your remedy lies in the realm of arbitration proceedings and not in the realm of court proceedings. The third question is the dispute even arbitrable or not? So suppose you're trying to get a declaration from the court that the patent itself has to be revoked as part of your counterclaim, or suppose you're asking the court to say that the design registration has to be cancelled. In those circumstances, those kind of reliefs an arbitrator can't grant as per law, right? So the dispute itself will not be arbitrable. So in those circumstances, even if there's an arbitration agreement, you will have to figure out if the dispute is arbitrable or not, and then take a call as to go to arbitration or mediation. The rule of thumb is court litigation is essentially you're one amongst the many people who come to the court, right? Your case is one amongst the many there. Arbitration, to put it very crudely, it's like a private court, right? Where you have chosen the judge and he has a certain level of dedicated time available to you, provided that you're able to pay the arbitrator's fees. So depending on whether there's an arbitration agreement or not, you have to decide where to go. Court, arbitration. If it is a case where you have to go to court, if it's commercial courts, explore whether mediation is necessary, not necessary. If it is not necessary, go straight to commercial court because you have urgent reliefs. If it is necessary, attempt mediation first before you come to the court. Any questions so far?
Yes, sir. I have just one question. So generally, IP laws, they are considered non-arbitrable as they are considered right against rem, right in rem. So
Right.
they are, but there is a judgment which says certain sub-rights in the IP in enforcing IPR are arbitrable. So can you throw some light on such?
Absolutely. So let's look at it this way, right? If you have a franchise agreement for your trademark, McDonald's has a franchise agreement with a person in India, right? Now tomorrow things go foul and the franchise agreement is coming to an end. Franchise agreement has an arbitration clause. Now, as part of your effort to resolve the dispute, you will also ask for an injunction restraining the former franchisee from using the trademark, right? Now, this is a classic example where, though it is involving a trademark, because it involves a particular right involving a trademark that is enforceable as a right in personam, you can still go to arbitration without having to go back to the court. But suppose the defendant comes back and says that, see, McDonald's is not even registrable as a trademark and I want the registration revoked. That would then involve a right in rem, right against the public at large, because you want a declaration of sorts to the effect that the person who owns the IP is not even capable of enforcing it. There, the arbitrator can't grant it. It has to go before a court of law. Right? So essentially, the way to look at it is the IP the subject matter of a contract? If it is a subject matter of a contract and there's a dispute, what is it that you want as a remedy in the dispute? If that remedy is a right in personam, then you can go ahead and invoke arbitration clause, right? But if it is not a right in personam, but involves, like I said, revocation of the registration of the trademark itself, then it is a right in rem that you have to exercise before a court of law. So that is how you distinguish between what is arbitrable and what is not. The other example is trade secret and confidential information. Now, this is IP, but this is the subject matter of a confidentiality agreement. Therefore, there is very much a scope for an arbitrator to get involved and resolve the matter. So no straitjacket formula can be granted. You have to essentially look at the facts. The first question that you ask yourself is the IP subject matter of a contract? If it is the subject matter of a contract, then the next question is the primary grievance a breach of the contract, which is the right in personam, or is it the breach of the right in rem, which is the patent or the IP itself? If the answer is latter, then you go to court. If the answer is former, where it's right in personam, then you go to arbitration. So you have to really examine it on a case-to-case basis and decide which way you want to go. So does that answer your question?
Yes, sir. Thank you.
Okay. So outside of arbitration, which is also a form of civil remedy, when you invoke a civil remedy, which is to either go to court or go to arbitration, your goal is essentially compensatory in nature. You want the infringing action to stop, you want your losses to be compensated, and you want equitable reliefs, right? For example, search and seizure orders in the form of an Anton Piler order, a Maravai injunction freezing certain assets so that it is not whisked away and made unavailable for assessing the evidence in the matter. So you could possibly ask for injunctions restraining them from infringing the IP. Account of profits, where you say that I want to ascertain the profits from the other party and then ensure that those profits come back to me as a result of the infringement. So the goal is predominantly compensatory in character and not punitive. Your goal here is not to punish. So if you're going there thinking that I'm going to get so much money that the defendant can never again recover in life, that's not going to happen. You have to prove every penny you claim as damages. You have to justify every remedy you want, and only then you'll get it, right? So if the goal is punitive, civil law is a bad option. But if the goal is to ensure there is compensatory reliefs, damages, compensation, injunctions, that is when you invoke a civil law, right? The other thing to keep in mind is civil law ensures that you have complete ownership over the enforcement effort. Criminal law, the enforcement effort is at the hands of the state, where you are just one of the stakeholders. Right? Criminal law is a lot more complicated because it is something that is also jurisdiction specific. In certain states, the police is very well equipped to address IP enforcement. So therefore, invoking a criminal law remedy for infringement is ideally suited because one, it doesn't involve as much cost because you file a complaint, you do a little bit of follow-up, and then the raid and the arrest happens. Thereafter, the state will decide to prosecute on your behalf and you don't really have to do much. But if the local law enforcement is not equipped for IP enforcement, there are systemic lacunae, the public prosecutors are not well equipped to enforce IP rights, then you will have to essentially decide whether you want to go with a criminal strategy or a civil strategy. Bear in mind that because a lot of these cases are triable before the magistrate, you can possibly file an application seeking leave to prosecute the offenders yourself and not leave it at the hands of the public prosecutor. But it has its own challenges, which is something that you'll have to carefully weigh. So assessing what is the jurisdiction, is the police capable, not capable, do they have sufficient means, not have sufficient means, will decide whether you'll invoke criminal law remedies or not. Criminal law remedies, in my opinion, are best suited for fly-by-night operators, counterfeiters, and piracy. So if you have somebody who is manufacturing fake Adidas shoes, right, that's a best example of a criminal law remedy being ideally suited, right? Or somebody who's selling illegal versions of a movie or a software, right? Because here there is no adjudication involved. On the face of it, it is infringement. But if it is a case where somebody is using a mark which is somewhat similar or identical, but there is a controversy there, right? You don't like Aisha and Asha. In those circumstances, criminal law remedies may not be ideally suited because a lot of times the police is not equipped to adjudicate whether what is similar or what is not similar. So if it is fly-by-night operators, counterfeiters, or piracy proliferators, that's when you adopt a criminal law remedy. Otherwise, you don't. And the next thing to keep in mind is the local dynamics are very important, right? In some instances, in some jurisdiction, you can go straight to the jurisdictional police station, coordinate with the inspector, and get a raid done. In some other instances, in some other jurisdictions, the inspector may not be the best person to act as the first responder for a variety of reasons, which are very complicated to explain. So then you have to probably consider going to the higher authorities like the Deputy Commissioner of Police, file the complaint there first, have them direct the inspector to give you all assistance when you go there, and then go to the inspector. Because sometimes when you engage with the police, there is a chance that because the defendant is locally entrenched where the police station is located, he might have ways of accessing information about the complaint even before you can undertake the raid, in which case your fly-by-night operator has disappeared. So you have to know the jurisdiction, know the dynamics with the police. This is also an area where you want to consult with a criminal law expert because they may have knowledge of this local dynamic, and then determine what is the appropriate strategy for enforcement, right? Because in one of our cases, when we were trying to enforce copyright in a TV channel, and there was illegal broadcasting, which is copyright infringement. When we went to the local police station first, the FIR got registered by afternoon. By evening, when we tried to raid the premises, all the equipment was already gone. Right? So sometimes you really have no means of ascertaining, what kind of dynamics exist locally. So always assess that before you invoke it. Now, the thing to remember with the criminal law forum is that it is a punitive measure. You want to punish the person. You're not going to get any compensation out of it. Even if you get it in the form of fine or penalty or compensation from the criminal court, it's going to be a pittance. Right? So if your job or the objective is to penalize or punish the infringer, and you don't want to spend too much time, effort, and energy in controlling the entire enforcement action, that's when a criminal law remedy is ideally suited, provided the person on the other side is a fly-by-night operator, is engaged in counterfeiting and piracy, as opposed to other nuanced forms of infringement, where, for example, question of similarity is still undecided. So with these things in mind, you have to take a call on whether it is criminal, civil, or ADR. So again, not a mechanical process. You need to sit down and have an individual conversation every time it comes up. Assess all the factors, gather all the data, and then take a call on which direction you wish to go. Right? Any questions so far? Okay. Now, trials in these cases are a very, very vast subject, right? Trial essentially is the examination and cross-examination of witnesses, right? The leading of evidence. So the meat of an enforcement action is the trial. Now, this is a separate subject which can probably be discussed maybe for an hour, 2 hours, falls back on conventional principles of evidence, then also has IP-specific principles. So we will not be able to touch the be-all and end-all in this conversation, right? But the one thing to remember is that in the course of the trial, unlike what they might show in some of these movies, you can never expect a defendant to admit everything that you are alleging, right? It's not going to happen. Nobody's going to come and say, I misappropriated the trade secret, right? Neither does the law expect you to prove it with that level of certainty, especially in civil law. Civil law, the standard of proof is preponderance of probability. The person with the relatively better case wins. So that being the case, the goal has to be realistic in a trial. What are you trying to achieve when you're trying to cross-examine? You have to be thoroughly prepared on the brief. You need to know every page of the evidence inside out. You need to know the facts inside out, because cross-examination, more than anything else, involves a thorough understanding of the brief in front of you, right? Some legal knowledge on the principles involved, very useful, no doubt. But that's probably 30% of the effort. 70% of the effort is just in knowing your brief inside out. Right? To the witnesses in your cross-examination, contrary to what they might show you in films, your effort is not to browbeat them. Your effort is not to intimidate them. Your effort is not to kind of humiliate them on the stand, nor to confuse them. Your effort is to be civil, dignified with them, build a rapport with them, so that they feel at ease to give you the truth of the information. Right? The more intimidating you are, the more guarded they become. The more guarded they are, less chances of them giving an admission. So adopt a very pleasant and civil and dignified demeanor in your cross-examination. Never go guns blazing, never scream at the witness, never intimidate the witness. In my experience, that is a useless exercise, not to be adopted unless it is absolutely critical, right? But you can't resort to that without first being nice. Right? The witness must feel that you are a friend, and therefore he can disclose to you whatever he or she has in mind. Right? Now, one of the things that you need to establish is in your cross-examination is what? That there is no dispute as to your ownership of IP. The infringement is more or less go to the root of the infringement. Is he using the trademark? How long has he been using the trademark? How long has he been using the patented invention? How much money that he has earned? These are the broad questions that you're trying to ascertain the answers for without directly asking them. Right? So you'll have to find an intelligent way to hit at this without really directly confronting the subject. Right? So try and your goal is what? To establish that your right is not in question, the infringement is not in question, and the extent of infringement is quantifiable to the extent of rupees so and so. So the entire goal of your trial strategy is to essentially get there. Right? And going to the root of how you can never expect an admission from the defendant in a trade secret misappropriation case, you will probably never have a situation where the defendant outright admits that he had taken the trade secret. Instead, what you will have to do is you'll have to establish during the course of the trial that the defendant had access to the trade secret, he had opportunity to misappropriate it, and his subsequent conduct seems to suggest that there is misappropriation of the trade secret. Like, for example, the launch of a rival product. So there are specific provisions of the Indian Evidence Act dealing with cross-examination. There are specific provisions in the CPC dealing with it. So make sure that you're thorough in all your understanding of the procedural laws, because that has a primary role to play even over the IP-specific laws on the subject. Okay, to conclude, bear in mind that registration isn't a guarantee that there will be no infringement, right? Registration only gives you a certain strategic advantage in taking action against infringers. Sound documentation of good business practices, very critical. You can have fantastic sales, but if the sales don't show the trademark product, then it's useless, right? So you need to ensure that your documentation for tracking your business practices is sound. Timely efforts to enforce. Never sit on your rights. The sooner you enforce, the better it is. Choosing the right kind of enforcement, civil, criminal, ADR, it's not a mechanical exercise, something that you want to apply your mind to. With that, we come to the end of the session. Thank you very much. If there's any questions, I can probably take it for the next 15 minutes.
Yes, any questions, anyone?
Yes, sir. So I just wanted to know whether, say, for example, if there's a startup or if there's a company or any organization which is not that well established, and
Right.
these bigger organization or bigger companies, they in order to suppress the startup, they come up with different lawsuits and they file these lawsuits against them, or maybe they just file 1 or 2 lawsuits. So can this emerging organization, can they go to CCI to just say that they are abusing their dominant position, or
Mere,
there are some
mere effort to enforce IP will not result in a competition law violation. Where competition law violations could arise in the context of IP is in patent bundling arrangements, standard essential patent disputes, where, for example, you have a standard setting organization which defines a particular standard to be achieved. And members of that organization know that to get from where technology is today to get to that standard, there are some patents in between that they're sitting on. They don't disclose it to the standard essential patent organization. They don't license it to the other members. When another member tries to get to that technology standard, they end up infringing the IP. So then this patent owner wakes up and files a lawsuit. So in those circumstances, the courts have come back and said that the conduct of the patent owner is also a violation of competition law. So, but mere efforts to enforce IP will not be construed as a competition law violation, because within the realm of competition law, what is recognized is that IP enforcement is a legitimate exercise of the right to compete, right? Because competition is in promoting free and fair competition. But if the competition is unfair and there is infringement of IP, even as an allegation, it is for the court dealing with it to resolve the matter and not for the Competition Commission to get involved.
Okay, sir. Okay, thank you.
So every point here was very relevant, very, very informative for all of us. And most importantly, I think to understand the concepts of cease and desist notice, as a very preliminary stage. That was one of the components of what we discussed also today, as what are the preliminary sort of preparations you need to make before you enter into a litigation itself. So I think that was a very important learning that we had. And also identifying the infringer itself, which is a challenging task. That's a very important takeaway again, to be able to identify the actual infringers and to hold the primary infringer as the first defendant. So these are, I think, the key takeaways that we have, and especially as practitioners, these are some of the most important things that we need to keep in mind, while filing infringement suits. And also the subject of expert evidence was discussed, and these are some of the key takeaways, I think, of this particular session. Anyone else, any other questions or any clarifications you want to seek? I think that's pretty much it.
Perfect.
All right. Thank you so much. Thank you, Ashok.
Thank you, ma'am. Thank you, ma'am.
For health condition, you could manage this whole session.
Thank you, ma'am.
Thank you for that. And thank you all. With this, we actually come to the end of this day's session. Today's session, this is all we had. And we will be continuing with the subject of IP litigation and enforcement. On the 2nd of March, we have 2 hours of session pertaining to IP enforcement again. adjudication and enforcement, where we'll actually be looking into some of the aspects of litigation. How do you prepare for litigation in IP? And what are the adjudication and enforcement aspects? Some of them were covered here today. And of course, we will have further discussions on this as well in the next session. However, we would like to meet with you all tomorrow morning at 9:30 for the sector-specific intellectual property sessions. Thank you all. Have a nice day. See you tomorrow.
Thank you, sir. Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.
Bye.